Good morning all. I'm excited to introduce you to today's webinar titled Risk Insurance, Ethics and the Reasonable Care Duty, brought to you in partnership with MetLife. My name is Cameron Byrne and I'm the General Manager of Partnerships here at the AFA. Today you'll hear from Dr. Jeffrey Scott, Head of Advice Strategy, MetLife Australia. Dr. Jeff has worked for over 25 years in the insurance industry. He is a regular media commentator on the topics of insurance, superannuation, pensions and finance. Jeff has conducted over 1,000 presentations in 13 countries, including the 2017 and 2010 MDRT. Jeff has lectured at the University of Technology, Sydney Investment and Financial Planning, and University of New South Wales, Taxation, Superannuation and Insurance. He created the first terminal illness benefit for life insurance products in Australia. Jeff has the following qualifications: CPA, SMSF Specialist Advisor, Fellow of the Taxation Institute of Australia, Bachelor of Mathematics, University of Waterloo, Diploma of Financial Planning, FPA and Deakin, Masters of Arts, Master of Education, Graduate Diploma of Advanced Taxation, Master of Taxation Law, and Doctor of Philosophy in Taxation. So it's certainly a very well accredited presenter today. In today's webinar, there are unique challenges when advising on risk insurance, as underwriting often requires highly sensitive personal information. This session looks at the series of legal cases involving TPD and trauma life insurance claimants and discusses the implications regarding the duty of disclosure to take reasonable care at underwriting, fraudulent claims, and the impact of product definitions. Before we begin, I would like to cover off some webinar housekeeping rather. Today's webinar has 1 hour of TPD available. The AFA will send details within the next week. We will answer questions at the end of this presentation. Please use the Zoom Q&A feature, not the chat feature, as you can see in the diagram on the slide. Jeff, thanks for putting this important information together to help our members. Let's kick off.
Thank you, Cameron. And thanks to the AFA for allowing both myself and MetLife to present today. This is a great opportunity for me to actually talk to you about a new piece of legislation that's coming through on the 5th of October, and talk about various insurance cases that also do this, that impact your clients with regards to all care, no responsibility slide. Everything I say over the next 45 to 55 minutes, if it's wrong, inappropriate, offensive, I hope my humblest apologies. I've tried to take all care to make sure that there's no errors or omissions. But if there is, again, please do your own research. So this is the starting point. So without any further ado, we'll get started. The agenda today, we're going to look at 6 different areas. We're going to look at life insurance structures. We're going to look at disruption in the life insurance advice industry over the past 7 years. Definitions of terminal illness and case law that goes along with it, duty of disclosure and the new duty to take reasonable care, what the differences are, what the similarities are as well, various legal cases, and also the interpretation of TPD definitions. And all this will hopefully assist you in providing appropriate advice to your clients and also deal with some ethical issues that we've experienced along the way. So, life insurance structures, why is this important? What I've realized is that if an advisor doesn't set the structure up right for a policy, then what normally happens is the goal that we have of right funds in the right hands at the right time often fails. So what you want to be able to do is ensure that no matter what happens, your client's wishes with regards to the insurance they have in place goes to the right people to help them out, whether it's themselves as the life insured, their families, their businesses, or their other loved ones. So life insurance structures, I want to go through this first. One, no matter what components, one is the policy owner. So the policy owner may be a natural person, maybe a corporation, or maybe a trust. And a trust includes a super fund. And the policy owner can transfer that policy to any other policy owner at any other time through what's called a memorandum of transfer. That's the first part. The second part is life insured. Every single life insurance policy must have a life insured. It's compulsory. And that must be a natural person. So I always go back to, I know how much people love their pets, but no matter how much, when I think about Michael Jackson and Bubbles the chimp, no matter how lifelike Bubbles the chimp was, he was not a natural person, and you couldn't take out a life insurance policy on Bubbles the chimp or any other pet you may have. Has to be a real person. Now, nominated beneficiaries. Who gets to nominate the beneficiary? People say, well, it has to be the life insured. No, it's not. The life insured is merely a pawn in this entire situation. So whoever the policy owner is gets to nominate who the life insured is, gets to nominate who the nominated beneficiary is. If there's no nominated beneficiary, then any benefits get paid to not the life insured, but I've got a policy that's on my own life. And if something happens to me, let's say it's my trauma policy, I'm the life insured, I'm the policy owner, and I'm the nominated beneficiary. So in that case, money gets paid to me. But you may have 3 separate entities for all this stuff. So the policy owner might be the husband, the life insured might be the wife, and the nominated beneficiary might be their adult children. People say you can't do that. Actually, yes, you can. So getting this right means that you get the right money in the right hands at the right time. And often when you don't do this correctly, things fall over. So that's the first part I want to mention about this. Now, role of life insurance, again, I'm going to go through something that's old school, but I keep on wanting to bringing it back because what I've realized is that many advisors who are new to the industry have forgotten this or haven't been mentored by people who've been in this industry for a while. Purpose of life insurance is to do 2 things. 1, eliminate debt. 2, create an income stream. That's it. And what they do for eliminating debt and creating an income stream is normally this acronym we call CYMER. So clean up funds for funeral expenses and all the rest of it after I pass away. Income, which is whether it be for income now or future income support for my family. Mortgage, be able to pay out my mortgage. Education, making sure my kids get an adequate education so they get to at least enjoy the same standard of living as I've enjoyed, or hopefully better. If I'm not there to be the principal breadwinner, there's something there for my spouse, or vice versa, because I've seen in many families now, the female is actually the principal breadwinner. So I can't gender stereotype that anymore. So what we have is a situation that CYMER becomes a big situation. People say, why is this important, Jeff? Because when we go back to what FASIA is looking for, what ASIC is looking for, they want you to be able to justify why did you recommend the various insurance policies to your clients at various times. So what I said to some people is that, how do you calculate the sum insured? First thing, I'm going to tell people to do this in reverse order. First thing is do number 3 first. Do a budget. Where's your money coming from? Where's it going to? Then calculate all your income and outgoings, and then calculate all your assets and liabilities. Once you understand that, then you understand where your gaps are, what you're trying to protect, and more importantly, how much is enough. And we've created what's called a house view at MetLife to make sure that we can actually describe this to clients. What do you need? How much do you need? How do you calculate it? And normally the general rule of thumb I've seen is that your insurance, depending upon your age, your health, your occupation, should be between 1% to 10% of your net after-tax income. And that's for an entire package. So that's what we're looking at. Now, people say, well, Jeff, why is this important? Well, what we've realized is why it's important because when we understand how much you need, the underwriters then also say, how much are we allowed to give you? And depending upon your ages, they will allow you to have sums insured, depending upon what type of cover you have, up to 25 times your life insured. And if you're closer to retirement, where you should actually already have a nest egg, it then is a smaller amount, anywhere from 2 to 5 times your income. So that's the starting point. And people say, well, why is that important? Well, if you don't have insurance, then all the financial goals people want to have go away. And it means that that safety net you have to create your wealth management and create your financial goals and your retirement goals means that you have to find some other way to put that safety net in place, such as a sinking fund, a line of credit, charity, sell assets, talk to parents or friends, maybe win a lottery. I think Powerball last week was $40 million. I didn't win. Otherwise, I may not be here. And assuming it will never happen to them, which is not recommended. Now, when I've talked to people such as like Louis Domofsky is head of wealth management research at Iris. He does the risk ratings for iris research. Incredibly good at what he does. And he said, Jeff, when an advisor looks at providing advice to the clients, they need to look at more than just the risk ratings. He said, the risk ratings are important, but you also need to look at the client's circumstances, what the underwriting is like, what the claims management is like, the financial strength of the company, and both short-term and long-term pricing for the policy. So he said the research that he does, he said it creates basically 1/6 of what you need to do for the entire situation for your clients. And people say, Jeff, you're getting boring on me. Why is this important? Because what I've seen over the past few years is what I call disruption to the life insurance advice industry. And life insurance is now quite definitely in the crosshairs of ASIC, and it's definitely being looked at by FASIA as well. So when we look at what's happened over the past 7 years, we had ASIC report 413, the Trowbridge report, life insurance framework was recommended. We had the Hayne Royal Commission, we've had FASIA, we've had the Hayne Royal Commission response, financial services reform, treasury laws, putting members' interests first. And these are just over the past 7 years. And this is purely focused on life insurance. Not only have they changed the legislation for us, but they've also started putting far more emphasis on advisors who have breached giving appropriate advice to clients. And so these over the past 7 years are people who have had insurance breaches for not giving appropriate advice to clients. What does that include? Well, what ASIC has said is, here are the things we're looking at. Did you act in the client's best interest? When you replaced a policy, was it actually providing a better benefit than the policy they already had? Could they afford the policy? Now, the one thing that they don't mention anywhere through here is that they don't ask, was this thing rated? So was the policy you currently have rated? So risk insurance ratings mean nothing. So ASIC doesn't look at risk ratings. They look at, was this better for the client based on their individual circumstances? So that's what they're looking at. So when we're considering all of this stuff, what do we need to look at going forward? Well, what we also realize is that if you haven't provided appropriate advice, clients are not only letting ASIC do their job, they're also willing to sue you as well. So these are 3 cases where the advisor breached their duty of care to their clients, and these 3 cases actually ended up in court. So not only is ASIC looking at this, but we also know clients are as well. So getting duty of care, that's the first step. When we talk about the underwriting, getting that right is vitally important. So first thing we're gonna look at is terminal illness. Now, what's happened with terminal illness? Why do I think it's important? Well, I was the person back in 1989 that came up with this idea. So it's been around for over 30 years. And I remember doing this little report for my boss. I said, I got an idea. And he said, what is it? He goes, I said, it's terminal illness benefit. He goes, what does it do? I said, we pay the death benefit early. And he looked at me, he goes, Jeff, interesting marketing concept, but it will never work in Australia. Well, 32 years later, on the 29th of June, 2015, so about 6 years ago, the rules changed. It went from a 12-month definition of terminal illness to a 24-month definition of terminal illness. And in order for that benefit to get paid out of superannuation, you need to have 2 doctors believe this person has less than 24 months to live, and one of them must be a specialist in the area on the injury or illness that the person is suffering from. So that's what they need, and those certificates must be there. So that's what they have for terminal illness. Now, when we get into the court cases, this is where we get to have some fun, because when I see the court cases, we start looking at duty of disclosure under the old rules and what will eventually turn into duty to take reasonable care not to make a misrepresentation. So what happened under this one particular case? Well, in the Tower versus Farkas case, the client has a policy that provides death and trauma insurance. The terminal illness benefit is paid on both the death and the trauma components of the policies because there's a terminal illness benefit in both parts. So he's got 2 separate policies that he has them. He's diagnosed with malignant non-Hodgkin's lymphoma. And again, this was when the terminal illness rules were 12 months. Both doctors looked at him and said, it's highly unlikely that you will live the next 12 months. He goes into remission, has a miraculous recovery, and survives. Lives longer than 12 months and all the rest of it. And the insurance company said, well, wait a minute, we don't need to pay this because this guy is terminally ill. He actually survived. We're not going to pay it. When it went to the courts, and the two medical practitioners, one of which was a specialist, basically said that it's highly likely this person will not live 12 months. As it was. What the court said was whether the historical fact that he lived and survived is irrelevant, because the future possibility when they did the assessment was that even with treatment, he'd still be terminally ill and die within 12 months, means that he met the conditions under the contract. And so thus he got paid even though he survived. So treatment needs to be taken into consideration, but the great thing about it is that he still got the benefit paid. So that's one of the things that you need to be mindful of, is that when they're looking at, well, is the person terminally ill? Is the person, in some of the other cases I'll show you later on, are they TPD'd? If they are, then again, treatment, future treatment to see whether or not this person can potentially get better needs to be taken into consideration, but it isn't whether or not the person ever gets better, it's whether or not they believe he will ever get better at the time of assessment. So that's the first bit. Now, duty of disclosure and duty to take reasonable care. This is new legislation. So beginning of this year, in January, the legislation changed. And people say, I didn't hear about that. Well, the legislation doesn't come in until October this year. So we'll take a look at this, but effectively the duty to take reasonable care will be replacing the duty of disclosure. So what happened? With the Financial Sector Payment Reform Commission Response Act 2020, which again came into force at the beginning of this year, what they've done is they've added a new section. And the new section is for what they call consumer insurance contracts. And a consumer insurance contract is a contract that's personal, domestic, or as a household purpose. So a personal life insurance policy falls under that criteria. People say, oh, does that mean that all the duty of disclosure rules are gone? And the answer is no. For group insurance contracts, duty of disclosure is still there. But for personal contracts, the insured's duty to take reasonable care not to make a misrepresentation has now been inserted. So this replaces the old duty of disclosure on personal contracts. So that's the first bit that's happened, and that's been inserted in section 20B. And then what they've also done is they've included this thing called relevant failure. So under section 27AA, what it states is that if in fact the person makes a relevant failure. Now we used to call this non-disclosure. So under the old contracts, the contracts we still see right now, that's called non-disclosure. But again, from October this year, from the 5th of October this year, going forward, it's no longer be referred to as non-disclosure. It's going to be called a relevant failure. So as part of this entire process, misrepresentation, so duty of disclosure still applies if a person is joining a superannuation or reasonable person test. So effectively, it's what I call the pub test. If I go to the pub, would a person at the pub think this was reasonable for the person to disclose this information? If the answer is yes, you need to. If the answer is no, I wouldn't have thought to do it, then you don't need to. And again, there's various things that go along with this. Now, I need to mention section 27A, what it says that if I have two contracts, let's say I've got a linked death cover and a linked TPD cover. And due to my situation where I did not take reasonable care to make a misrepresentation, the insurance company would have still given me the death cover, but wouldn't have given me the TPD cover. Then they have the right to separate the contracts and still provide me with the death cover. So again, that's what the section 27A does. It allows you to, if you have a combined policy, it allows them to split it up if it's possible and give you still cover on the stuff that you would have got cover for, even though you made misrepresentation on the other bit. So that's the starting point. Under section 20B, it's now being rewritten because it used to be talk about misrepresentation and duty of care. It now says an insured has a duty to take reasonable care not to make a misrepresentation to insure before the relevant contract of insurance is entered into. And you say, well, that sounds a whole lot like the old duty of disclosure. And for the most part it is. But what you're going to see is that on the application forms going forward, at least from October going forward, the insurance companies will basically be putting in new questions or more expanded questions to make them hopefully far clearer and less ambiguous, so that the client has the ability to take their reasonable care. Now, again, insurance companies have the right to opt in before October. So some of them might be going early, some of them may have already done so, but again, all the way through. The situation with 27AA is that the relevant failure occurs in a consumer contract where misrepresentation is made by the insured in breach of duty to take reasonable care not to make a misrepresentation. Going, oh, Jeff, what the hell does that mean? What that means is that the person still has to, when we think about the old duty of disclosure, they still got to make, if it's reasonable for them to do so, they've got to tell the insurance company all relevant information associated with applying for the policy. Makes kind of sense. Now, one thing I need to make comment on, Section 59A, many advisors, there are a lot of advisors I've dealt with that are still not aware of Section 59A, and this has been around for about 6 years. It says that an insurer under a contract of life insurance may cancel the contract if the life insured has made a fraudulent claim. So if I've gone to the insurance company and I've faked my death, and don't laugh because I've actually seen a situation where a person's faked their death and then they showed up in front of an ATM taking money out the next day from their actual bank account. But in that case, if I've been fraudulent with regards to applying for making a claim, then the insurance company has the right to cancel that policy that I was fraudulent on, plus every other policy I have with that organization. So again, please be aware of this, that's kind of important. Now, Section 29 basically says what happens if I've had a relevant failure. So if I had a relevant failure, the insurance company has the right to modify the sum insured or cancel the policy. So from here, this is what the context is. So if a client isn't sure, should I tell the information or not tell the information? Please remind them to tell the information, as much information as you possibly can. Now, Mel, I'm going to put the first polling question up for you because I believe we're at the right slide. And so the first polling question, if you could bring that up, that'd be greatly appreciated. So the first polling question for everyone is, can a life insurance company cancel a policy if a life insured commits fraud when making a claim? Mel, I reckon we've got about another 10 seconds. From what I'm seeing so far, we have a lot of very attentive and smart attendees. Of the 93% who currently said yes, I think they've done a very, very good job. So thank you for that, Mel. So 93% said yes. Well done, everyone who said yes. That would be the right question. And so I'm going to move to my next slide. So client's duty of disclosure, not to make a misrepresentation. If I have committed fraud at any time, if I've committed fraud, the insurance company has the right to cancel my policy. That's the first bit. The second bit is that if I've had what's called a relevant failure, this used to be called misrepresentation or non-disclosure, but it's now called relevant failure. If I had a relevant failure within the first 3 years, the insurance company has the right to either vary the contract or avoid the contract from inception. If it's beyond 3 years and it's not fraudulent, then the policy stays in force for death cover, so there's no changes. But for TPD, trauma, income protection, and business overheads or business expenses, in that case, the insurance company has the right to vary the policy. So Mel, I'm going to go to our second polling question. We'll go for about another 10 seconds, Mel, then we'll show the results. Thanks, Mel. So can a life insurance company reduce the sum insured? The answer is yes, they can. So they have the right to modify, or they have the right to modify or vary the contract if the life insured does not take reasonable care to make a representation. So again, the insurance company has the right to vary the sum insured. So again, great result. Well done, everybody. Again, 79% got the question right, and the other 21%. Again, my slides will be available afterwards on the AFA website. We'll move to the next slide now, Mel. Thank you. So legal cases. This is where I get to have some real fun. With the legal cases, this is where we actually see where non-disclosure and various other things have actually had an impact on a client's situation. So when we look at this, duty of utmost good faith. This has been around, duty of utmost good faith between both the life insurance company and the life insured has been around for over 100 years. So the Carter versus Bowen case was the very first one where Lord Mansfield took a look and said, duty of utmost good faith are on both parties, both the life insurance company to pay all legitimate claims if the client's done the right thing, and on the client or the life insured to disclose all relevant information. And again, this is a mutual situation. What they said is that the responsibility of the life insurance company is to live up to the standards of common decency and fairness. So not try and avoid the policy, but go from there. So I think this is actually a really good situation. Now, what happens we've seen? Income protection duty of disclosure. The Bokenstein versus Tyndall case was a precedent-setting case. Income protection policy, client was a mechanic who injured his back. So there's no doubt about it that the client actually had a physical impairment that actually caused him to stop working. The policy was issued in March 1993. The injury occurred in July 1993. So those are facts that were locked in concrete. The client stated that he earned $60,000 per annum. And so he had the benefit that he was paying. We're asking for the person's financials. They realized that he had never earned more than that he never earned more than $25,000, even with doing jobs on the side. He never had a year where he earned more than $30,000. What the court said in this was that the client actually stated his income with what was called reckless indifference. And since he stated his income with what's called reckless indifference, the income being insured for, the court said was just as important as disclosing health issues. So in this particular case, I thought they would have reduced the sum insured. They didn't. They said since he stated his income with reckless indifference, he had never earned more than $30,000 per year. He actually insured for a case of fraud. So what it showed was that income disclosure was equally as important as health disclosure when applying for a life insurance policy. This next one, train casualty in life versus Hall. Client suffered from headaches and vomiting once per month. Diagnosed as fit as a fiddle by her doctor, and she was never off work for more than 14 days. Now, why was 14 days important? Because the 14 days was the waiting period on her income protection policy. Now, Ms. Hall, the headaches and vomiting that happened once per month was associated with certain things that happen once per month in females. And so when that occurred, she thought this was normal. She had headaches and vomiting. She was never off work for more than 14 days. She hardly ever missed work at all. So she thought, and her doctor said, there's no problem with you. This is normal. It got to such a point where her headaches became so severe and the migraines became so severe, she went off work. And she went off work and basically put the claim form in to get her income protection benefit paid. The insurance company said, well, you didn't disclose this past case of headaches and vomiting, so we're not going to pay the benefit. When it went to court, the court said, well, wait a minute. let's look at the reasonable person test. The reasonable person test said this happens every month, right around the same time every month. And this was quite normal, and quite normal for about half the population, that she would get a headache. And she then went to her doctor, and doctor said, there's nothing wrong with you. You're as fit as a fiddle. So she got medical treatment, said she was no problem. And this is something that probably half the population suffers once a month. So based on that, and based on the reasonable person test, should have she disclosed the headaches and vomiting to the insurance company? And the answer was no, because with the reasonable person test, would you disclose every time you had a cold to the insurance company? The answer is no. Then in that case, this would be irrelevant. So based on the reasonable person test, this benefit got paid. Why? Because she had headaches and vomiting. She didn't think it was serious. She got assessed by the doctor. The doctor said, you're as fit as a fiddle. There's nothing wrong with you. Based on the reasonable person test, she disclosed the right amount of information. There was no non-disclosure issues. There was no misrepresentation issues. Benefit got paid. Love this case. This case was an interesting one as well. Death cover policy with sum insured of $1.5 million. First policy was purchased with AXA in 2004. Second policy was applied for in 2012 with AIA. Client informed the advisor of a stomach issue. Client saw the doctor between the application and the acceptance by AIA. Client failed to tell either the advisor or AIA of the results of the medical test. The advisor didn't ask the client the results of the medical test before canceling the existing policy with AXA, and client was diagnosed with terminal cancer. So in this situation, where's the duty of disclosure that the client has? Is it at application stage or when? Well, in every insurance policy, the clients have a duty of disclosure up to the time the policy is issued. If the policy isn't issued, the client still has a duty of disclosure. So in this case, did AIA pay the benefit to the client? The answer was no, they didn't. So in this particular case, did the insurance company have the right to avoid the policy? The answer is yes, because the client failed to disclose relevant information up to and including the time the policy was issued. So application form is one situation, but if it takes 4 weeks, 6 weeks, 8 weeks, 12 weeks to get through the underwriting process, if anything happens during that period of time before the policy is issued, the client has a duty to disclose that information to the insurance company. Now, this case, Graham versus Close, a brilliant case. Death cover policy for $1 million. Client died in a fire in January 2010 due to smoke inhalation and burns. So basically his house burnt down, his smoke inhalation and burns, and died in the fire. And so his business premises burnt down. So, and they found out that he had intentionally set fire to his business premises. Things weren't going well, set fire to the business premises, smoke inhalation, died in the fire. But what the insurance company realized was that he'd been on antidepressants since 2002. He'd been on psychological counseling since 2005. He had fainting spells in 1999 and saw a neurologist in May 2007. So before he actually purchased the policy in June 2007, he'd had all this stuff and didn't disclose any of it to the insurance company. So the question would have been, did the insurance company pay this benefit? And the answer was no, because they said that this was such a gross case of non-disclosure or gross case of misrepresentation, they would have never entered into the policy with the life insured. So again, if clients have issues, please make sure that you tell them, disclose as much of the stuff up front as possible, whether it be under the old duty disclosure rules or the new duty to take reasonable care not to make a misrepresentation rules. Again, they come in October. They have this, there's this same responsibility for things that they know or should have known. Please make sure they disclose it to the insurance company. This case, again, comes back to the situations. This is Somerton versus SGIC Life Insurance. Applied for $300,000 worth of death cover, accepted at ordinary rates on the 24th of May. He was diagnosed by his doctor with a kidney tumor on the 23rd of May. The policy then went into the client received confirmation of the policy on the 2nd of June. So that's when he actually received the policy document in his hands. So at what time was his duty of disclosure relevant to? Well, his duty of disclosure was relevant up to and including when the policy was issued, so the 2nd of June. Anything that he found out from the time he applied for the policy all the way through, he had a duty to inform the insurance company of any changes in his health situation. So when he was diagnosed with a kidney tumor in 23rd of May, 1995, he had a responsibility to inform the insurance company. Since he didn't, the policy went in force. The insurance company had the right to avoid the policy, and that's what happened in this case. The benefit did not get paid. So this one's an interesting one. This is Tyndall Life versus Chisholm. Client applies for a $500,000 death and trauma policy. Great situation. Purchased it in 1991. Now, he applied for the policy, went through all the bits and pieces, did the application form, and since due to the sum insured at the time, they basically said, well, we want you to have a full medical. So he goes, okay. So he went to the doctor assigned by the life insurance company. So it wasn't his doctor, went there. The doctor did a full medical test, poked him, prodded him, ECG, EKG, blood test, urinalysis, the lot. After that happened, he then went on and had the policy in force. What then happened approximately 18 months later was that he ended up having colon cancer. And what would happen was that he had been to his doctor on a couple of occasions for past cases of rectal bleeding. And he argued that the policy should still be paid, the benefit should be paid to him because, again, he filled out all the forms and the doctor that did the medical on him that was assigned by the insurance company didn't ask him about any of this stuff. And so the question was, since the doctor didn't ask him and it wasn't on one of the forms, did the client have a duty to disclose this information to the client? And the answer was, duty to disclose this information to the insurance company. And the answer was, does this pass the pub test? People go, what do you mean? Well, if I went to the pub and I said, oh, I've got a sore throat, should I disclose that to the insurance company and say, well, we'll give you a throat lozenge. Now, if you have a throat lozenge, is it better? Yes. Well, probably don't need to disclose it. Is that normal? Oh, yeah. On the other hand, is it normal for people to have blood coming out of their bum? Because that's what rectal bleeding is. And most people say, whoa, if I've got blood coming out of my bum, that's kind of serious. Well, that's right. So if the average person in the pub would think that blood coming out of your bum is serious because you had rectal bleeding, then that's stuff you probably need to disclose when you apply for a life insurance policy. So in this case, based on effectively what they call the reasonable person test or the pub test, if you went to a person in the pub and said, I have past case of rectal bleeding, do you think I should mention that on my application form? Everyone would go, yeah, that's kind of serious. You probably need to mention it. So in this case, the benefit did not get paid because of that past case of rectal bleeding that he did not disclose. Now, trauma cover duty of disclosure, I love this policy. So Stone versus Tower, 2003 case, client applies for a term and trauma policy. He has an existing term and trauma policy with another company. Sum insured on each policy is $1 million. The second policy is accepted subject to the cancellation of the first. So the insurance company says, we see that you've got another policy with another company. Please cancel your other policy and we'll be happy. And the guy says, I promise I'll do it. He doesn't. The insurance company issues the second policy. Client fails to cancel the first one. Premiums are being taken out of his bank account every month. He forgets, and then he happens to suffer a heart attack about a year later. In this case, who pays the benefit? Company one, of the original policy he had. Company two, which is the new policy, they said, we wanted you to cancel that policy. Does he get paid from company one, company two, neither, or both? Well, in this case, he actually got paid from both. Why? Because the issue of the second policy was not what they called a condition precedent for the second policy to be issued. So The second policy didn't say that this policy will not go in force until you cancel the other one. They just asked the person nicely, please cancel your other one. Since they asked them nicely and they didn't follow up, the insurance company said, well, you've issued the policy. Second policy was still in force. You didn't make it a condition precedent. So we're going to basically make you pay both. So this client, when he had his heart attack, got paid both policies. Now, what have various insurance companies done since 2003? Well, most of them now make it a condition precedent that says we won't issue your second policy until the first policy has been canceled, or this policy will not be enforceable unless you have it, and they usually have it in their application form. But in this case, since there wasn't a condition precedent when that second policy was issued, then both benefits got paid. He got paid $2 million, $1 million from company A and $1 million from company B. I love these cases. They're great. Now, TPD duty of disclosure. This one was a great one as well. Muggleston versus National Mutual. Client purchased an income protection and TPD policy in 1995. In 1999, his knee became too inflamed and too swollen to work. In 1994 and 1995, he visited his doctor and received anti-inflammatories for his knee. When he was applying for the policy in 1995, he disclosed to his agent at the time all the things that was wrong with his knee, because they played football together, they played rugby together. And so Muggleston said, mate, you know me, we played football together, you know what's wrong with my knee, and I've had various problems with it. Should I mention it? And the agent said, no, don't worry about it, mate. We'll just fill it out. No need to worry about the knee. You're okay. Won't be a problem. Completed the form, sent it in. And sure enough, in 1999, he couldn't work. The insurance company said, well, wait a minute. You didn't disclose you had a problem with your knee. And he said, well, I did. I told my agent failed to put it on the form. Since the person was an agent of National Mutual at the time, the agent was deemed to have received the information on behalf of the insurance company. So the disclosure actually occurred. So in this case, there was no non-disclosure because to the agent as a representative of life insurance. If anything were to happen today, where he, who is independent from any life insurance company, then in that case, it would not have been disclosure because it didn't make it through the insurance company and the benefit would not have got paid. So again, slightly different situation, difference between an independent financial advisor and an agent. An agent's deemed to have received the information on behalf of the life insurance company. Again, difference in situation between what happened in 2004 and what we happening in 2021. So this one, client suffers post-occupational dermatitis, was off work from 1990 to 1992 due to the condition. He was a spray painter. And as he was spray painting, he was inside a confined, he was in these painting booths doing the spray painting, and he was in there for long periods of time, and he basically ended up getting bad case of dermatitis and eczema. So he was told by his doctor, you can't be in the, you can't be a spray painter anymore because that reaction that your skin has to the fumes of the paint basically causes you to get dermatitis and eczema. And he goes, okay, we'll stop it. So he stopped it. He then became a forklift driver for another organization. When he joined the super fund, they said, have you had any problems, any issues? And he goes, no. He basically, because the dermatitis had gone away, because he thought the dermatitis was associated with an allergic reaction or a reaction to the paint that he was using. What ended up happening is he joined the new fund. He was there for a while. He had death and TPD inside the fund, and he didn't disclose his post-occupational dermatitis because he thought it was not an issue anymore. But then in 1994, he ceased work permanently due to post-occupational dermatitis. He was told by his doctor was that the reason that you had the dermatitis in the first place was a reaction to the paint. He believed that since he was not in the paint, associated with paint anymore, he wouldn't have a problem. What they realized was that his dermatitis was actually stress-related. That wasn't diagnosed. When he actually did this, passing the reasonable person test, did the benefit get paid? The answer in this case was yes, the benefit got paid. Is based on Mr. Hudson's knowledge at the time He didn't believe that the dermatitis was ongoing. He didn't believe that it was going to be an issue, and he thought it was all directly related to his interaction with the paint fumes in his old job. Again, so did it pass the pub test? The answer is yes. Did the benefit get paid? In this case, the answer was yes. Great situation. This one, Schaefer. Love this one as well. Client's comprehensive respiratory test, inconclusive, not disclosed. So basically, she goes, I'm having shortness of breath. I don't know what the problem is. And when got tested. So she got tested by multiple doctors, multiple specialists. They all came back and said, there's nothing wrong with you. Don't worry about it. She goes, okay. They thought it was possibly asthma. They thought it was possibly reaction to pollen or various other things or allergies. And they said, no, there's actually nothing wrong with you. So she goes, okay. So she went and joined, got a insurance policy, has TPD insurance. 2 months after policy commencement, she starts a new job, and she's breathless and diagnosed with being stress-related. 2 years after policy commencement, she quits work due to respiratory problems. And so the question becomes that she knew she had a problem previously. She didn't disclose it. Does the benefit get paid? In this case, the answer was yes, it did. Why? Because she said, I went to my doctors, went to numerous specialists, and they all said the same thing. There is nothing wrong with you. You're perfectly fit. You're perfectly okay. There's nothing to disclose. So she didn't. And when it went to court, this benefit got paid. Why? Because it passed the pub test. It passed the reasonable person test. That when it came back and said, is this worthwhile? The answer was yes, it was. So we have this situation where this was actually put in place and the client got the benefit paid. Now, Mel, I believe I missed our last 2 polls. So let's do both polls at the same time. So humblest of apologies. I was talking too quick and I haven't put them in there. So let's do these 2 polls right now, Mel, and then I'll get on with the rest of my presentation. So next poll, can a life insurance company deny a claim if a life insured grossly exaggerates their weight when applying for life insurance? Another 10 seconds. And the results, 90% said yes, a life insurance company can deny the claim, and those 90% would be correct. And again, what grossly exaggerates their weight, the example that I saw in one of the case studies was that a person applied for life insurance for death cover. They stated that they were 85 kilos. By all the doctor's reports and everything else they did, they were probably, they were actually between 180 and 100 and, between 180 and 200 kilos. So person grossly exaggerates their weight, can the insurance company deny the claim? The answer is yes. If you're off this is the risk. We'll go to the second polling question, Mel. Sorry, the last polling question. Can a life insurance company cancel a policy if the life insurance commits fraud during the underwriting process? Another 10 seconds, Mel. And the results, again, The answer is yes, a life insurance company can cancel a policy if the life insured commits fraud during the underwriting process. And again, it's the difference between fraud and misrepresentation. Fraud is reckless indifference to the truth, or has an intent not to provide accurate information. In that case, the answer is yes. And again, fraud has been committed. The insurance company has the right to cancel policy at any time. So home stretch, I think it's last 10 minutes before I'm done, then we'll go to questions. TPD definitions. What we'll do with this is there's been a few changes to case law on this. So first one happened with Kylie Rebecca Drury versus First State Super Trustees in 2005. Client was an office assistant. Client had repetitive strain injuries to her forearms and wrists and elbows. It was determined that she could no longer be an office assistant based on the jobs that she did. She then applied to the super fund to get her TPD benefit paid out. And the individual was asked to undertake retraining. And they said, the insurance company said, it's reasonable for you to be able to do another occupation. Based on your education, training, experience, we believe that you could be a weight loss consultant. We believe that you could be a radio dispatcher. We believe that you could be a tour guide operator. We believe you could be an auctioneer. We believe you could be a photographic developer. So back in 2005, when people still had proper photos, you could do that. So that's what they said that you could do. And what they realized was that based on her education, training, experience, because again, in this case, Ms. Drury was in her 20s. They said, is it reasonable for a person in their 20s to retrain from a unskilled office worker to another relatively unskilled job? And the answer is yes, it was. So in this case, they believe that due to the fact that her retraining would not be an issue and the retraining would not take a significant amount of time, it is reasonable for her to retrain to another job, and the benefit did not get paid. Now, this one, this particular case is a precedent-setting case, came out in 2017. So Hanover Life Re versus Jones. In this case, again, he had any occupation definition of TPD. They said, what is reasonable based on your job? And they said, you've done a bunch of things. You're a tradesman, roof plumber, you've done a bunch of other things, and you've had repetitive strain injury and lower disc. And in October 2011, they said, you're not going to ever work again in your current job as a tradesman roof plumber. The insurer comes back and says, we believe you could be a retail, you can work in retail sales. So like an Bunnings, you can be a courier deliverer, delivery driver, wasn't going to say the word, I'll be fine. Console operator or customer service administrator, telemarketer. So they said, you can do these jobs. When it went to the court said, actually, these jobs aren't reasonable because this guy has been a tradesman roof plumber for the past 14 years. And that's all he's known. He's been a tradesman roof plumber. For him to retrain to be almost anything else, does he have the skill set and could he actually train up? And they said, well, quite simply, he's been a tradesman roof plumber for, again, 14 years. And he's been doing something this since 1998. So almost 20 years, I believe he can do. So quite simply, this benefit got paid because due to how skilled his trade was and how long he'd been doing his trade, it was not reasonable for him to retrain to do something else, such as those other roles, due to what he could do. So quite simply, he got his any occupation TPD benefit paid based on education, training, and experience. And the big one with this was his training and experience. His experience was almost 20 years in this chosen profession. It was not realistic for him to retrain to something else. Now, this last one. This one was a precedent-setting case. So the Shootrim case was precedent-setting. Client basically said they were TPD. He was an auto mechanic before he became a police officer, couldn't do the police job anymore. And when he went to become TPD, there was this thing about unlikely versus unable. And there used to be a really big differentiation between if a person says unlikely or says unable, they're two different standards. And when it went to court, the judge presiding over this case said, wait a minute, unlikely, ever, and unable effectively now mean the same thing. It doesn't mean less than 50% chance. It means that if it says unlikely or it says unable, it both means merely a remote or speculative possibility that the person will ever return to their usual occupation based on education, training, experience. So again, it doesn't mean, oh, they could possibly return. It has to mean merely a remote or speculative chance. So again, this isn't one of those things of, so it meant that the definition for TPD actually got raised to be a more difficult one. So unlikely, where this is unlikely, or where this says unable, effectively now means the same thing. So in summary, relevant failure of income is equally as important as disclosure of health. And that was the Wilkinson versus Tyndall case. Retraining can be considered prior to claim payment. So this was the Rebecca Drury versus First State Trustees. The reasonable person test, which we saw a bunch of those. Again, if it's the reasonable person test basically says we believe that this person could, the person actually disclosed the right information, and you went to the pub, and relevant failure, the reasonable person test will be even more so. And this is what Justice Hayne, as part of the Hayne Royal Commission, brought to the fore. And then the other thing, contracts except death can be varied at any time due to a relevant failure. We used to call this non-disclosure. It's now called relevant failure. Cameron, I'm going to put it back to you. So if there's any questions, comments, concerns, issues, or protestations, let's hear them.
Yeah, thanks, Jeff. There's only one question come through. Insured retains existing cover until 3-month exclusion for pre-existing conditions has passed. Perhaps the insured should disclose to the new insurer intention to retain existing trauma for 3 months to negotiate commencement date.
Yeah, good idea. Especially during that 3-month period, you don't want to have your client not covered. And so what I would do is that if the client's going to do that and retain their old policy until that 3-month qualification period has expired, really good idea. But again, disclose it up front, talk to the underwriters. Most of the underwriters are quite practical in this situation. So have a chat to your underwriters, and what they will normally do is they'll basically put a note in there saying, old policy to be canceled after this has been enforced for at least 3 months. But yeah, you don't want to leave your client uncovered. What the other companies will do though as well is that what some companies will do is that if you're replacing an old trauma policy with a new one, they will often waive that 90-day exclusion period for things such as cancer, heart attack, stroke, or bypass. So again, let the underwriters know, and they'll in many cases they will waive that, especially if you've already gone through the qualification period with the old policy.
Yeah, so I just think we've got time for 2 more questions. How reliable is the notion that unable and unlikely are effectively the same meaning now? Do we cite that slide in our SOA if one insurer says unable and the other says unlikely in their PDS?
Yes. So this is that particular Shootram case was a precedent-setting case. When I talked, the lawyers went absolutely crazy over this. So when I went and looked at some of the various legal websites on the Shootram case, that unlikely versus unable became a very important differentiation. In the past, when that came through, they said, there's nothing to differentiate anymore. So you can still differentiate based on own occupation and any occupation. But when you look at under an any occupation definition where it says unlikely or unable, effectively it means the same thing.
Okay. Just one more question, Jeff. Can you, and we've only got a minute to go, can you see a reason why an office worker, accounts clerk, would have own occupation TPD against any occupation?
If I'm an unskilled worker, the any occupation will force me to retrain to another role. If I've been doing the same job for a long period of time. So if I'm in my 20s, then own makes a lot of sense. If I've been doing the same job for the last 45 years, is it worthwhile that I get an own versus any? And again, based on not the education, not the training, but the experience perspective, the longer I've been in the role, the more the any occupation definition starts to mimic an own occupation definition.
Okay. So, Jeff, on behalf of the AFA and our membership, I'd like to thank yourself and MetLife for presenting the webinar this morning. I hope our members have found it very insightful, and I think I certainly learned a few things that you've spoken to today that have been updated since my time as an advisor. So I really appreciate the support of yourself and to MetLife as a key partner to the AFA. So on that note, keep safe, everyone, and good afternoon.